Okay, I need you to understand what is allegedly unfolding right now, because if these reports turn out to be accurate, we are witnessing something that has never occurred at this level of American political life. According to multiple unverified sources, a federal judge has reportedly issued orders involving a member of a prominent political family. And the timeline of events being described, if true, escalated in just days. Reports suggest court filings were submitted, enforcement actions were allegedly authorized, and family testimony was reportedly provided that legal observers describe as unprecedented. And here's the part that makes this situation potentially extraordinary, according to these sources. The alleged failure to comply with reported court orders has reportedly triggered enforcement mechanisms that are rarely activated for high-profile defendants. If you value analysis that examines legal claims critically and helps you understand what would need to be verified before treating allegations as fact, make sure you're subscribed to this channel with notifications turned on, because what potentially unfolds from here could test how legal institutions handle high-profile cases. What we're examining didn't begin with verified court documents that mainstream outlets have confirmed. According to various sources circulating these claims, it allegedly began with reported legal proceedings stemming from claimed financial irregularities. Let me walk through what these sources are alleging step by step, while being clear about what has been verified and what remains unconfirmed. According to these reports, the timeline allegedly unfolded over several days. The sources making these claims describe a Thursday court filing, Friday enforcement authorization, and Saturday family statements, all occurring within a compressed period. That kind of rapid escalation, if accurate, would be unusual in federal proceedings, which typically move more slowly. The speed itself raises questions about whether these events occurred as described. Here's what these sources claim is in the alleged court documents. According to reports, a filing was supposedly submitted that described failure to comply with a court-ordered surrender deadline. The specific language being quoted by these sources includes terms like willful noncompliance with lawful judicial mandate. However, without independent access to verify these documents exist in official court databases, we must treat these as alleged quotes from claimed filings. The sources making these claims describe specific page numbers, document references, and filing dates. According to these reports, one filing allegedly references financial transactions totaling specific amounts routed through business entities that were reportedly registered shortly before other events in the timeline. If such documents exist and contain what is claimed, the timing would indeed raise questions. But again, none of this has been confirmed through channels that allow independent verification. Stay with me here, because this is where the alleged family testimony becomes relevant to the claims being made. According to these unverified sources, a family member was reportedly subpoenaed to provide character testimony, which is standard practice in sentencing proceedings. The sources claim this testimony occurred, and they characterized the responses provided as distant, measured, and strategically non-supportive. Specific exchanges are being quoted, including alleged responses like, "I am not in a position to provide that testimony," when asked about character. If such testimony actually occurred and was characterized accurately by these sources, it would represent an unusual family dynamic. Family members in federal proceedings typically provide supportive testimony when called as character witnesses. The alleged refusal to do so, according to these reports, was then cited by the judge in subsequent enforcement orders. However, we have no way to verify these transcripts exist or have been accurately quoted. Let me be specific about the evidentiary problems with these claims. First, federal court proceedings of this magnitude would be covered extensively by established news organizations. Major outlets have legal reporters who monitor federal court dockets, attend hearings, and report on significant filings. The absence of such coverage from mainstream sources is a significant indicator that these proceedings may not be occurring as described. Second, federal court filings are generally public documents, unless sealed for specific legal reasons. If the documents being described existed and were accessible, journalists and legal analysts would have access to them. The fact that these alleged documents are being quoted by alternative sources but cannot be located in official court databases raises serious questions about their authenticity. Third, federal law enforcement actions involving high-profile individuals generate enormous attention. If marshals were actually dispatched to locate a fugitive family member of a former president, this would be national news, covered by every major outlet. The absence of such coverage is notable. According to these circulating reports, the evidence allegedly includes multiple categories. The first category reportedly involves financial documents showing awareness of questionable property valuations. The sources claim joint tax returns were signed over multiple years, creating potential legal exposure for all signatories. The second category allegedly involves communications, including text messages and emails, discussing property values and loan applications. The third category reportedly consists of witness corroboration from accountants and bankers. If these categories of evidence actually exist and contain what is claimed, they would indeed be significant in any federal financial fraud case. Tax returns signed under penalty of perjury create legal obligations. Communications discussing valuations in connection with loan applications can be relevant to fraud allegations. Corroborating testimony from multiple witnesses strengthens prosecution cases. But all of this is predicated on these documents and testimony actually existing, which has not been verified. The sources making these claims also describe alleged deleted communications that were reportedly recovered. According to these reports, text messages sent the night before a surrender deadline were deleted but then retrieved by prosecutors. The content of these messages, as characterized by these sources, allegedly discusses preparations that prosecutors interpret as flight planning. If such communications exist and were characterized accurately, they would be relevant to any flight risk determination. But again, no verification exists for these claims. Let me address what the other perspective on these allegations would be, because understanding both sides is important, even when dealing with unverified claims. If these allegations were being made against someone, that person's defense would likely argue several points. They might claim selective prosecution based on political identity. They might point to other cases with similar allegations that resulted in different outcomes. They might question the timing of enforcement actions in relation to political calendars. They might challenge the characterization of communications and financial transactions. These would be legitimate defense arguments if actual proceedings were occurring. The question is whether the proceedings themselves are real, which brings us back to the verification problem. We're being asked to evaluate defense arguments for proceedings that may not actually be happening. According to these unverified reports, the alleged family testimony created escalation in enforcement. The sources claim that within hours of the deposition, the judge issued orders authorizing marshals to take action. The specific language being attributed to the judge includes citations to family testimony suggesting pre-planned non-compliance. If a judge actually wrote this in an order, it would be a significant finding, but we cannot confirm such an order exists. The reports also describe alleged responses from family members through social media and legal representatives. According to these sources, statements were made denying wrongdoing, characterizing proceedings as political persecution, and claiming testimony was taken out of context. The characterization of these statements varies across different sources reporting them, which itself raises credibility questions. Here's what would need to be established for these claims to be treated as verified fact. First, there would need to be confirmed reporting from established news organizations with direct access to court documents. Second, there would need to be statements from official law enforcement sources confirming enforcement actions. Third, there would need to be publicly accessible court filings that can be reviewed independently. None of these verification markers exist for the situation being described. What we may be witnessing instead is how detailed speculation can create impressions of authenticity without actual verification. The level of specificity in these claims, including document page numbers, specific dates, and quoted testimony, creates an appearance of reliability. However, specificity alone does not establish truth. Fabricated claims can be elaborately detailed. The question is whether those details correspond to verifiable reality.
This raises broader questions about information assessment in the current media environment. When extraordinary claims are made about high-profile individuals, particularly claims involving criminal proceedings and law enforcement actions, certain standards should be applied. Can mainstream news organizations confirm the claims? Are official court documents publicly accessible? Have law enforcement agencies made statements? Without affirmative answers to these questions, claims should be treated as unverified speculation. If any portion of these claims were to be verified in the future through official channels, that would fundamentally change the analysis. Verified legal proceedings would deserve serious examination. Verified family testimony creating legal exposure would represent significant developments. Verified law enforcement operations would raise important accountability questions. But the critical word is verified, and that verification has not occurred. Let me walk through what would actually happen if the scenario being described were real. If a federal defendant actually failed to surrender as ordered, a bench warrant would be issued. That warrant would be entered into national law enforcement databases. Marshals would be assigned to locate and apprehend the individual. This process generates documentation that would be accessible to journalists and legal analysts. The absence of such documentation from verifiable sources is significant. If family members actually provided testimony in federal proceedings, those proceedings would have court reporters creating official transcripts. Those transcripts would become part of the court record. Attorneys would reference them in subsequent filings. Legal analysts would review them. The fact that no such transcripts can be located through official channels suggests they may not exist. If federal law enforcement were actually engaged in locating a high-profile fugitive, official statements would be made, press releases would be issued, law enforcement sources would confirm operations to journalists. The silence from official sources on what would be a major enforcement operation is telling. So where does this leave us? It leaves us examining claims that have not been verified through reliable sources, analyzing what would need to be true for those claims to be accurate, and noting the absence of verification markers that would normally exist if such events were occurring. This is not the same as proving the claims are false. It's acknowledging we don't have sufficient evidence to treat them as established fact. For those following these types of allegations, the framework for assessment should be consistent. Ask what verification would look like. Ask why that verification hasn't occurred if the claims are accurate. Ask which sources are making claims and whether they have track records of accuracy. Ask whether mainstream outlets with resources to verify claims are reporting the same information. These questions don't automatically answer whether something is true or false, but they help calibrate our confidence in the information being presented. The pattern we're observing involves claims being made with increasing detail and authority despite lacking verification from established sources. This creates challenges for everyone trying to navigate information in the digital age. We must maintain standards for what constitutes verified information, even when claims align with our existing views or expectations about certain individuals. If you value analysis that prioritizes verification, acknowledges limitations in available information, and applies consistent standards regardless of who is being discussed, make sure you're subscribed. Because in an environment where detailed claims circulate rapidly, the most valuable skill is distinguishing between what is confirmed and what remains alleged.